In the previous lesson, what we did was talk about the general rule for finding liability in the case of negligence for an omission rather than an act. And we noted that the general rule was that there is no liability owing to the fact that there is no duty of care, and as a result of which there is no breach of said duty. Well, in this lesson, we're going to talk about the exceptions to this general rule, talk about some of the examples where we have found that liability for an omission does take place in the context of the tort of negligence. So, like I said, we're going to talk about the circumstances, essentially, where an omission does lead to a claim in tort, a successful claim in tort, and the processes by which the failure to act in a certain way could give rise to liability. Now, it's only in very specific circumstances and in very specific relationships that this takes place, and that's obviously part of the general rationale behind having and ensuring that there is little liability for omissions generally in the law. So, liability can arise from omissions in a number of different circumstances. We won't cover all of them in much detail in this lesson, but we will cover some of them. We'll cover some of the more famous cases. And maybe in the future we'll come back and do some more looking at some of the other details, or even potentially making a members-only lesson on going into a little bit more detail on this particular topic. But the ones that we are going to cover are as follows. We're going to talk about the idea that there is an assumption of responsibility which is established, whereby a breach of that responsibility can lead to liability by way of an omission. You can have a situation where the defendant in question is the creator of a source of danger resulting in the injury in question. And you can also talk about the existence of something known as a control relationship. These are three circumstances by which liability for an omission can arise. Let's begin with the first one. So, the idea of the assumption of responsibility suggests that the relationship that exists between the parties in the litigation will create said assumption. So, if there is an assumption of responsibility on the part of the defendant towards a claimant, then a failure to act in a way which essentially gives rise to that standard could lead to a circumstance whereby there is liability through omission. Look at the following example. This is from the case of Barrington Ministry of Defence from 1995, and the facts are as follows. So, the background essentially involves a military base where there were regular occasions of heavy drinking sessions. So there was a lot of drink, a lot of alcohol getting involved, a lot of people getting very, very, very drunk in these different circumstances. The claimant was the wife of one of these individuals who, after drinking too much, the individual, not the wife, the individual was drinking too much, they would go back to their room under the auspices of a duty officer where he would be left unsupervised. Unfortunately, as a result of being left unsupervised and as a result of the heavy drinking, he would be sick and then choke on his own vomit and eventually would die. Now, the issue for the court here was the fact that the claimant was the wife, and the claimant was therefore then bringing a case in the tort of negligence as a result of failing to essentially supervise this particular individual, which resulted in his death. Does the Ministry of Defence, who were the litigants essentially, have a duty of care such that the facts of this case would breach said duty by omission? And it was held that while the Ministry of Defence does not have a general duty of care in relation to the prevention of excessive drinking by their employees, that is not something that is within the remit of the Ministry of Defence. The fact that when the victim had become ill from drinking, the duty officer then assumed a responsibility by helping him back to his room, and the act of then leaving him unsupervised was a breach of duty on the basis of the omission, failing to essentially supervise this very drunk individual. So the assumption of responsibility gives rise to a duty of care in this example, owing to the fact that the duty officer takes care of the individual but then fails in their duty to take care by leaving them unsupervised. This is where the duty of care arises, and this is where we get liability in this case. So What this essentially tells us, therefore, is that the assumption of responsibility for the individual by the duty officer was breached not by an act in any way, but actually by an omission to supervise him while he was sleeping. And so, as a result of which, you can see an example where liability arises for an omission. The second circumstance where liability can arise out of an omission is through the creation of danger yourself. So if a defendant is responsible for the danger which could give rise to the specific liability in question, and they fail to prevent or remove said danger before there is any injury in question, then it is said that they can be liable for negligence as a result of the omission. So the creation of the danger could be said to be an act. It could also be an omission as well. But it's not just the creation of a danger. It is a creation of a danger and then failing to prevent or remove the danger, which gives rise to the liability through negligence. This has been particularly difficult for the courts to establish. In the case of Top and London Country Bus Limited, for example, it was held that there was no duty of care to prevent a bus from being stolen when the driver left the keys in the ignition. The idea here is what happened in this case was that the bus was stolen by a thief, and then that thief then went and killed a passerby, and this was the wife of the claimant who then made the case. And it was held that despite the fact that it probably was the fact that the individual in question created the danger by leaving the keys in the ignition, the duty of care was not found to be to exist, and so therefore there was not a duty of care to prevent the bus from being stolen. Finally then, what about the existence of a previous relationship? What does this mean and how does this apply? Well, if there is this existence of a previous relationship, then depending on what this relationship is, there can exist omission-based liabilities. And one of the key cases here is the 1955 case of Carmarthenshire County Council and Lewis. Essentially in this case, a child was part of a nursery school and they had ran out of the school premises into a busy road. And in order to avoid a child, a driver had to swerve to get out of the way, and they hit a tree and unfortunately died as a result of this maneuver. And the wife of the driver would then sue the county council and the teachers on the basis that the nursery school teachers had a duty of care to look after the children on the premises and to stop them from escaping. And so by failing to do so, they have been negligent through an omission. And the issues in this case, as you can imagine, was can a duty of care arise from the fact that teachers had control of the children, therefore had a previously existing relationship of control, and therefore had a duty to prevent them from becoming a danger to others? It was held in the affirmative that yes, they did have a duty of care owing to their existing relationship of control, and the failure to provide such a relationship of control by omitting in essentially their duties to keep an eye on the children and to stop them from being dangers to others led to a breach of said duty, which gave rise to liability through an omission.